time and again reiterated that revenue records are not documents of title and they do not vest the right of ownership as a property to the individual named in the land record. Reference are so many references is there. I am not, this is an elementary thing. Any law student also know this branch of law. Unfortunately, this has not been taken care of by the central government. Clause 5E, the proposed amendment amounts to create subclause among the Muslims for the purpose of giving birth to give this dispute. Clause 9 of the proposed bill provides to clause 9 is totally unacceptable and it provides 2 members appointed under this subsection shall be non-Muslim. The exclusion of Muslim, the exclusion of Muslim community persons from holding the post of 2 members in the Waqf board is hit by Article 14 of the Constitution of India, which provides equal opportunity to everyone. In the case of Hindu temples, the non-inclusion of Hindus cannot be imagined. We can't imagine. For example, under Section 6, subsection 2(1) of Uttar Pradesh Kashi Vishwanath Temple Act, it has been specifically mentioned that there are 3 eminent Hindu scholars well versed in the Hindu. A line has been set, a point has been taken. You see, these are the state law, but it is a central law. Law means within the ambit of Article 246 of the Constitution of India. Law doesn't mean beyond that 246. If a law is within the Article 246 of India, there cannot be discrimination between a state law and central law. This is kind of unthinkable stand has been taken. I cannot think about this. After long 44 years practice, I can't think. No, it's a state law. This can be, it cannot be compared with the central law. What is that? Law is having its own force. Read Article 13 of the Constitution of India also. What is law? Madam, Clause 11 of the proposed bill seeking amendment of Section 14. That is amendment of original act suffers from same illegalities. Clause 14 of the proposed bill whereby Section 20A of the original act, that is removal of the chairperson by vote of no confidence, has been deleted. Such deletion is also improper, illegal, because if the chairperson does not enjoy the confidence of the other members, how can he sit there? It's a question of democracy. If the chairperson does not enjoy, madam, can you sit there if you don't enjoy the majority's confidence? If you cannot enjoy the majority's confidence, you have to leave. That is the democratic setup in our country. Madam, amendment of Section 36, subsection 3 is effectively taking away the power of the Waqf board. Regarding receiving of registration of Waqf, and such amendment has been empowered the central government in an indirect manner to control everything. All powers have been taken. Why you are not making it the Honorable Minister? The Minister of Minorities will decide everything. He will be the supreme. Nothing is required. Finished. You can do it. Clause 20 of the bill amending of Section 40 of the original act. If Section 40 is deleted, madam, the Waqf board power itself will be teethless doll. If Section 40 is amended and Section 40 is taken away, the Waqf board will be a teethless doll only. If Section 40, then there is no necessity to keep the Waqf board itself. Do not keep it. Keep the power with the minister of the central government. Minister will decide what is the necessity of the Waqf board. Everything will be done by him. Because the power to regulate and statutory Waqf board. This is complete. Madam, I will take some time, please. Complete reason I am reading very fast. I am going very fast. Waqf board. The proposed amendment bill under clause 21 seeking amendment of Section 46 of the original act once again empowers the central government to make regulations with respect to so and so. Therefore, state power has been taken away. Does it not violate the federal structure of this country? Every power of the state government has been taken away. Only central will do it. That cannot be. It violates the fundamental character of the Constitution. Clause 22, Amendment Section 47 of the Act. The proposed amendment empowers Central to call for the audit of any Waqf board by the CAG. How the CAG can make an audit? CAG can make an audit in a case of consolidated fund. CAG can make an audit in a consolidated fund under the Constitution. How CAG can make an audit beyond the consolidated fund. This is absolutely illegal and improper. Madam, Section 50, under the existing provision of the Waqf Board, then comes Section 83. By the proposed amendment, the members of the tribunal has been reduced to 2 and 1 person having knowledge of Muslim law. This has been done, it has been amended. Now the tribunal to order is tribunal to High Court. Tribunal to High Court under appeal. Now it is a statutory appeal. There is no provision for condonation of delay if there is any delay is done. If a direct is a statutory appeal, you have not given any power to grant any interim relief to the persons. How can be an adequate remedy? Earlier it was there, one could have gone on Article 226 of the Constitution for a judicial review. And High Court is having the power to condone delay and also to pass an interim order. This power you have also taken away. Therefore, this provision is not an adequate remedy so far as the Waqf property is concerned. Madam, please. Madam, the High Court has not given any power. Madam, 107 and 108. I am going very fast. I am getting very fast. I am not taking even the water even. The proposed amendment has an effect on the decision to replace the survey commissioner. Then the underclause proposes Section 107 of the Act is deleted and thereby non-applicability of the Limitation Act. That is divorce. How the Limitation Act will be applied? If the Limitation Act will apply, so many disputes will come. This is the intention of the government. Open, sab khulo abhi khul do rasta. India mein chala laga do. Hindu Muslim laga do. यही तो इंटेंशन है उन लोग का. क्या होगा? This is not correct. This is completely bad. The proposed Waqf Act proposes significant. In Hemant Waris sir has also criticized the concept of adverse possession as unjust, urging reforms to protect rightful property. Therefore, this is a this is a clear attempt. This is a clear attempt on the part of the bill to curtail the right of the Muslims in our country. ये ठीक नहीं है. मैडम, हिंदू या मुस्लिम का हसद मत छेड़िए. अपनी कुर्सी के लिए जज्बात को मत छेड़िए एक जंग मिलजुल कर गरीबी के खिलाफ. दोस्त मेरे मजामी लकबत में मत छेड़िए. मैडम, हम अपनी जान का दुश्मन के अपना जान कहते हैं. मोहम्मद का इस मिट्टी को हिंदुस्तान कहता है. अब तो मजहब अब कोई ऐसा भी चलाया जाए जिसमें